Hi, my name is Zach Perry. I'm going to be answering the question today, when does attorney-client privilege begin? It's actually a pretty common question and a little bit complicated. As a preliminary matter, there is something called confidentiality and there's something called privilege, and the two terms are often interchanged, but they really mean something quite different. Confidentiality has to do with an attorney's duty to maintain the confidentiality of certain communications conveyed to the attorney. Privilege, on the other hand, has to do with in court, an attorney's right to object and refuse to answer a question under the basis of privilege. So confidential information is the attorney's duty, and he can use the privilege rule as a shield in court if someone is trying to get at confidential information. Now, attorney-client relationship doesn't technically begin until the client has, until there's been an agreement between the attorney and the client that the attorney will represent the client, and also until the client has asked the attorney to pursue some course of action on their behalf. However, just because you do not actually sign up with an attorney doesn't mean that the privilege and the confidentiality don't apply, because the confidentiality provision in the rules of ethics predate the actual formation of the attorney-client relationship. So my duty to prospective clients regarding confidentiality is the same as my duty towards my actual clients. What that means in practical terms is if you call an attorney and you are asking questions of the attorney, seeking advice to determine whether you want to even hire the attorney or whether you even need to hire an attorney, those discussions aimed at discovering whether you're going to retain the attorney are confidential, unless certain exceptions apply. For example, if others are present, then you've waived confidentiality. You can also voluntarily waive confidentiality. There are certain times when an attorney may or must breach confidentiality, like in certain cases involving crimes, like if you're planning to commit a crime, an attorney can disclose that. But for the most part, an attorney has the duty to maintain the confidentiality of information you provide to the attorney, even if you don't end up hiring the attorney. And this rule of confidentiality is sacrosanct. It is something that the courts will uphold. So speak with confidence, knowing that when you seek advice from an attorney or when you retain an attorney, that attorney will maintain the confidentiality of the information you provided to him. And of course, the reason behind the rule is to encourage you to disclose all, so the attorney has all the information he or she needs to pursue your case if that's what ends up happening.
Lawyers Plus, we earn your trust.
Do you need to speak with a lawyer? If so, call one you'll actually like.